Governor J.B. Pritzker saying the law he signed is necessary to limit court venue shopping. But a Madison County court saying that the law is unconstitutional. Got the governor's reaction to that earlier finding by a court saying that the court limits venues for saying, hey, you can only file lawsuits against the state of Illinois in either Sangamon or Cook County, none of the other 102 counties in Illinois. And the Madison County judge saying that that's just not convenient and unconstitutional and is applied to the Piasaw Armory's challenge of the state's firearm liability law. Welcome back. Greg Bishop. Each and every weekday morning hanging out with you with Bishop on Air. Like, subscribe, hit that notification bell, and join us as we break down things happening in and around the state. So let's go ahead and get on into this. Of course, you have the story that we talked about earlier this week where a Madison County judge has declared the state's law limiting where people can file lawsuits as unconstitutional. So go check out the article at thecentersquare.com/Illinois. Madison County judge finds Illinois' lawsuit venue limit law unconstitutional. And this was in the Piasaw Armory challenge against the House Bill 3062, which the governor signed last year. And if you recall, last year, when this was debated in the Illinois House and the Senate, there were accusations that this was a tyrannical law. But you had the supporters of this essentially saying that they needed this for a variety of reasons, because especially during COVID-19, all of the executive orders that the governor had about masking and social distancing and keeping kids from going to school for being a suspected COVID spreader, those were challenged in the courts, and they were challenged in all kinds of different counties across the state. So the proponents of this law ultimately were looking at trying to limit where the state had to go and defend against challenges that the laws and executive orders are unconstitutional. And that was brought up during the debate last year. But you also had individuals suing across the state, challenging state law in state court when it comes to the gun ban. And if you recall, attorney Thomas DeVore, he had, 7,000 plus different individuals getting temporary restraining orders for months on end while those cases played out. So that all, of course, was essentially done away with when the Illinois Supreme Court made their ruling, but DeVore was attempting to get those cases reinstated, saying that the case the Illinois Supreme Court heard from Dan Calkins was not the same case that Tom DeVore brought forward. So those, we'll have to get an update as to where we're at with those particular cases, because I believe on appeal, those were essentially not happening, right? So now it's on appeal, and we'll get an update on where that's at. But regardless, the venue limiting law the governor signed, it says you can only file suit in Sangamon or Cook County. So this is obviously an interesting law that was passed that Republicans said was tyrannical. Well, my colleague, Katrina Peterson with the Center Square, attended the governor's news conference yesterday and asked for his response to his law being struck down as unconstitutional in the Piasaw Armory case in Madison County. Here's what the governor had to say.
Well, first, let's characterize it properly. It's our law in the state of Illinois, and my reaction is it'll obviously run through the court system. I signed it. I think it's something that makes sense for just organizing the court system, so there's a lot of venue shopping going on by people who are just trying to find a friendly judge here or there. The experts that are, in the two venues that have been designated seem like they have handled constitutional related cases more than any others, and so it makes sense to me to have those cases run through those.
So the governor essentially saying that the other judges across the state in district courts don't have the experience dealing with constitutional cases as there may be in Cook or Sangamon counties. And Sangamon County is in central Illinois. That's where the state capital is. Cook County, of course, encompassing Chicago. So none of the other 100 counties have judges that could deal with constitutional cases, as Governor J.B. Pritzker said that's his belief. and that the Sangamon and Cook County judges and district courts have dealt with these types of cases more often. So again, that's his rationale for it. And he says that the challenge here from Madison County with the case that Piasaw Armory brought against the state's firearm industry liability law. He says the challenge to the court limit law will make its way through the courts. So we'll see where it goes with a possible appeal, because the state has until the end of this month to appeal that decision out of Madison County. So we'll be watching that closely. But again, the governor saying that, hey, it's our law and it's necessary.
Well, first, let's characterize it properly. It's our law in the state of Illinois, and my reaction is it'll obviously run through the court system. I signed it. I think it's something that makes sense for just organizing the court system, so there isn't a lot of venue shopping going on by people who are just trying to find a friendly judge here or there. The experts that are, in the two venues that have been designated seem like they have handled constitutional related cases more than any others, and so it makes sense to me to have those cases run through those.
So again, in that ruling that the Madison County judge found the court venue limit law as unconstitutional applied in that case, the judge said the law does violate due process as applied to persons who reside and are injured outside of Cook County or Sangamon County. The judge said that the motion to transfer is denied as the law is unconstitutional as defendant seeks to apply it. And it also goes on to ultimately highlight how in that motion to move to Sangamon County, the state said that litigants can remote in with video conferencing, but the judge said the state could also do the same with video conferencing into Madison County. The court's aware of the Supreme Court rule, the judge said, allows broad use of video conferencing and telephone at the evidentiary hearing or trial for good cause shown and upon appropriate safeguards, or even as of right. However, the availability of remote proceedings does not bolster the state's argument. The state could also participate in Madison County using the same remote means. So interesting to read that, and we reviewed that case in some detail with the order that was issued in March 1st of this year, which, by the way, happy Pi Day. So you've got the layout there from the judge saying this is unconstitutional, and the argument that the state made. It doesn't cut muster. So again, we'll watch this and see where it ultimately goes. But I mentioned attorney Thomas DeVore, and he's got, of course, the situation that several different lawsuits he was looking to have brought forward. He had the thousands of individuals who had temporary restraining orders against the gun and magazine ban. During COVID, he represented parents and students across the state, thousands of them getting temporary restraining orders, preventing enforcement of mask mandates and, keeping kids from going to school and social distancing and things along those lines. So he had all these cases spread all throughout the state, right? And the state had to go from district to district, and a lot of times via Zoom. I was monitoring these cases via Zoom. So even with Zoom being there as a possibility, the state still had to get to these court cases and whatnot. But aside from all of that, DeVore facing another challenge, and not just the challenge of bringing lawsuits against the state on constitutional grounds, but now he's facing a challenge dealing with the Attorney Registration and Disciplinary Commission. So I want to take a quick look at this, and then we'll get Attorney DeVore's reaction to it in a statement that he sent me. And here's what the ARDC, the Attorney Registration and Disciplinary Commission, breaks down. It's a complaint that's filed, and they're investigating it. Count 1, conflict of interest, inappropriate sexual relationship with a client. And it goes through the detail of DeVore and his relationship with Riley Craig. And it breaks down all the specifics and, the payments and things along those lines. But then you get to some of the other counts. Count 2, conflict of interest, improper business transaction with a client. It goes through some of those allegations as well. And again, this is just being investigated. And you've got the 17-page document breaking down these things. Count 3, using means for no other purpose than to embarrass, burden, or delay a third person and filing frivolous litigation. That's count 3. Here it says that Craig filed Chapter 7 bankruptcy. And then Craig sent an email to the respondent informing him that she had filed for bankruptcy. Respondent received that email. Respondent, in his capacity as an attorney for Future U, sent an email to Craig and 3 creditors of Future U, a business they were in with each other. In the email, respondent stated to creditors in reference to Craig's bankruptcy, this is not a personal debt of Riley, but as you can tell, she's ignorant of pretty much anything. Hence, why she has treated like a child, why she was treated like a child with lack of access to the finances. So interesting to see some of these allegations, and you can find this with the Attorney Registration and Disciplinary Commission. And read all of that for yourself, all 17 pages. But I did reach out to Attorney DeVore to get a statement, and he provided me with a statement and said that it must run in full. So I will read this to you here with Bishop on Air from Attorney Thomas DeVore. So here's the statements that Attorney DeVore put out. After 2.5 years of being in an interpersonal relationship, in February 2023, I ended the relationship with Mrs. Craig because I was unwilling to be blackmailed by her any longer or further subject her to her maniac outbursts. On May 7th, 2023, Ms. Craig demanded I continue to invest significant resources into our business, which was unsuccessful due to her inability to effectively manage it. Our marketing person had recently quit because Ms. Craig was volatile and hateful to him in the same fashion she was to me. When I told her I just couldn't put any more money into the business, she threatened she would go to the ARDC to tell them that she was my client when we began seeing each other on June of 2020. She said it didn't matter if it was true or not, and that she was a 28-year-old single mother, and they would believe her regardless of whether it was true. Even though in June of 2022, she made a long statement on social media telling which was the truth that she was not my client when we began dating, she now changes her story out of spite and hate. Even though I supported her and her son in every way for over 2 years, she immediately turned into a vengeful person merely because this one time I just couldn't see fit to continue putting money into the business. She also threatened to file bankruptcy and destroy our business for the sole purpose of sticking me with the company debt. When I told her that I would not be blackmailed, she followed through on her threats, and for the 4th time in 2.5 years, Riley and or her family made claims to the ARDC about alleged misconduct. Additionally, Ms. Craig intentionally destroyed the joint business by locking its social media accounts and making numerous false statements to all of its customers, which resulted in them no longer doing business with the company. All of this was done by her solely due to the fact that I refused to give her money. I made various efforts to try and protect the business from her intentional acts of destruction, but was unsuccessful. While the first 3 times with substantively similar allegations made to the ARDC resulted in immediately closure, for reasons which are hard to appreciate, this 4th attempt now requires I defend myself at a hearing. I will defend myself at the hearing against what are intentional acts of hate and spite from an extremely troubled individual. I will make no further comments on this matter. So again, that's a statement from Attorney Thomas DeVore in reaction to the ARDC complaints that was made public this week. So just getting you guys the latest here. Of course, we've talked to Tom in the past about the gun ban litigation, but clearly he's got some other challenges he needs to address as well. So maybe we'll connect with him sometime in the future to get more about this ARDC complaint and status of what happens to those cases challenging the gun and magazine ban moving forward. All right, be sure to like, subscribe, hit that notification bell, and join us as we do our thing each and every weekday morning here with Bishop on Air. Appreciate you guys being here.